State of Florida versus Sarah Boone, 2020 CF 2603.
Murder trial involving defendant Sarah Boone. She's accused of second-degree murder after she zipped her boyfriend up in a suitcase and left him there to suffocate and die, according to police, back in 2020.
She says she was playing a game. That video does not sound like any game I've ever heard anyone play.
It's really a bizarre case, a lot of strange circumstances, but it's for real.
She's the one who talked to the police officers. Again, you have the right to remain silent.
The problem is I fell asleep. I fell asleep when...
You fell asleep?
This segment's brought to you by Don't Talk to the Police.
In her mind, that explanation was sufficient. She's practiced that. That was something that she looked over and say, I'm gonna just say this and they're gonna understand me. It's bad.
In this case, the suitcase is the alleged murder weapon.
Her previous attorney had enough of his client and asked the judge to remove him from the case.
This is bad. This is bad. So it's so bad that any attorney trying to tell her how bad it is, she's not going to listen.
They're going to think I killed him.
First of all, no one asked her that question. She's being interviewed, she's kind of frantic, and then she just blurts it out. It's interesting subconsciously what is on her mind.
Boone says he dropped the ball and has not been representing her fairly.
Everything that she did afterwards, and what the hard part is, it's her own doing. It's bad.
Ashley Kane says, thank you, ladies, for this. Stay safe, Sam. Oh, thank you. That's sweet of you.
Thank you. I appreciate
All right.
that.
Let's talk about this motion in limine. So basically, what did I tell you guys? I said he's not done with this interrogation. He's not done with it. I knew he was going to come back and try to get portions redacted. And I guess that's what's going on here. Have you looked at it, Sam?
Yeah, I did. I didn't see your email last night. But I did see, I think maybe at 3 o'clock in the morning I saw this. So what we've got is a motion in limine, which I've been talking about. We were going to see motions in limine coming. It's standard. It's also standard to come pretty close to trial. He's just trying to eliminate. He's trying to eliminate some of the information out of this interview that we know is coming in.
You know what I find interesting about what these redacted portions are? These, to me, because I just went through the interrogation once again because I'm doing some clips of it. This particular piece is when he had what's her name left the room.
That's true.
So it's just this piece where he's talking about the neighbors and how the neighbors all talk about her being drunk, and she's going on and about the neighbors, and then what's her name comes back in the room because at the scene of when the cops were coming in, I guess there was a couple of people that wouldn't let her use the bathroom, and they, she went over to their house, they can use your restroom, and they were like no, and so he was bringing that up, saying all your neighbors think you're a drunk. So then Copsell comes back in the room and he's like, he just explained to her, no, that's what we were just talking about. Then later in the interview, when Copsell leaves out of the interview room again to go get the Rosenberg or Rosen, whatever her name is, the CSI lady, he says it's the part where it's really quiet and her and Lowen are sitting there and she's like, I don't think you'll understand what I'm going through. It basically says, he's like, well, he's dead as a result of your actions. And she's like, are you trying to make me feel worse? But it's kind of that time period where they did this. And it says, she goes, wait, Detective CK, Copsell said that. She goes, oh, wait, this was when Copsell was in there. Okay, my bad. Well, he's dead as a result of your actions. And she twice, it looks like. And Sarah says, I understand that. And then Lowen says, I have one last question. You do realize you're the person that killed him, right? And Sarah says, I thought about that. And then you hear Lowen say, well, intention or not, George is dead. You act like when you say unintentional, that absolves you from everything.
Yeah.
So it wasn't that part where she was okay. I jumped the gun a little bit there. So it's not a huge portion of it. I don't know if it's going to make any difference, to be honest with you.
No, it probably won't. I mean, let's face it, the cell phone videos are damning. You can't get away from that. Thank you for your super chat, Janice. The screaming match was noted on her jail behalf or log. Another YouTube channel had the log sheet. So maybe it was from a different day. Fixing my typing error. Here, she's got another one. I'm afraid to click on anything, Carrie, because I'm you and not me. The screaming match was, this is from Janice. Another super chat, thank you again. The screaming match was on her inmate behavior log for the 5th.
The
5th. 7th, yeah.
Thank you for your super chat, Janice. For the 5th, which was Saturday, like she said. Okay, well.
Yeah.
Don't know. I'm sorry, y'all.
Either.
Don't know. I don't have the jail insider drama.
Well, so listen, my stepmother lives down here in the central Gulf portion of Florida. She texted me on Saturday and she said, "Is this trial going to be delayed?" I'm mad about the storm. I'm not mad that I have to leave. I'm mad about the trial getting delayed. Like, okay.
You know what's funny about that is that, well, didn't you say she wasn't really watching or into it until?
No, she wasn't. I sent her, I originally sent her the interview we did, and then you had created a playlist, so I like texted it to my parents and stuff, and she started paying attention. So she's like, "What have you done to me? Now I'm hooked." She had to have emergency hip surgery yesterday, so.
Oh, she's stuck at home, yeah.
Yeah, if you're listening, Susie, I hope you're feeling better.
Hey, girl, hey. Yeah, I hope you're feeling better. So you guys, once we do get going here, this is long-awaited justice for Jorge Torrez Jr. and his family. I mean, literally 16 continuances, 4 years, 7 months later. Can you imagine if you were one of the family members and having to deal with that?
No.
I have. Oh, Mark, thank you so much for your memberships gifted. You're so kind, my friend. I appreciate you.
Northwest said, "P.I.C. I'm worried you are tired. I am. Please take care of yourself. Thank you. I'm trying. Your safety more important than us." Yeah. Thank you. I appreciate that. Doing this, though, is better than stressing here, without anybody to talk to about it.
Yeah. Thank you, Laria. Margaret, thanks for a great channel. Carrie and Sam, be safe.
We got a new channel member, Chaucer Nerd. Is that what this is? Chaucer Nerd is a new member.
Yeah, I'm getting there. John Sanchez says it was a super sticker, which lovely old what StreamYard doesn't always pop those up. Thank you, John. Appreciate your super chat. Chaucer.
I think it's Chaucer Nerd. Chaucer.
Well, thank you for becoming a member. Oh, John did it again. Okay, he says they want to throw it out because Sarah tells them that Eli is over here illegally. Oh, good. I got you. Good point. Yeah, I'm literally I'm doing a thing for you guys, and I don't know when it's going to be finished, but I'm breaking down her little pieces from her interrogation and doing a Sarah contradiction piece. But it's funny how she just, like, everybody gets thrown under the bus when it comes to Sarah saving her own butt. You're absolutely right, though. But that piece is kind of like she goes from trying to defend herself and then, by the way, he's down here illegally. I mean, I'm not trying to get him in trouble or anything.
Right, exactly. It's like that's going to deflect from the dead man in your apartment, Sarah.
Yeah, yeah, exactly. And Christy, thank you for becoming a new member. That's awesome, you guys. Thank you, and welcome aboard to the memberships for whoever Mark gifted memberships to. All right. What do I want to talk about next? I've got a list here of things I wanted to talk to you guys about.
Totally. Terry just said it escaped me. Will you show jury selection? We will show jury selection if it is aired. Court is not scheduled to start right now until 9 o'clock Eastern time to 8:25. We don't know whether or not it'll be broadcast or not.
Okay. Yeah, we're just waiting for them to come up. We're early.
Mm-hmm.
Let's see. Oh my God, there's like 322 messages in here. I do want to show you guys something here. I've got. There's the one of the, what's her name? I don't want to do anything too big. I'm trying to find something that's small because I don't want to start anything too big right now. Julie Harper.
People are asking if I've ever seen a jury selection broadcast. I have not, so I don't know the answer. You're saying yes. Has Florida done? I think it's up to the judge. Do you think?
Yeah. I'm sure it's up to the judge whether or not media is allowed in there. And let me show you guys something really quick. I did want to play this morning as we're waiting for jury selection to begin.
Is defendant present at jury selection?
I don't
Absolutely.
know what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning. Get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous.
I love him. God
Mm-hmm.
love him.
Mm-hmm.
Now, Sam, you've been to this Orlando courthouse. Well, no, you've been to jail.
Mm-hmm.
You've been to the Orlando jail.
I have.
Okay, so but you've been with the defendants.
Yes.
Well, do you want to tell everybody a little bit about what you do and how you've been with the defendants when it comes to what goes on in the mornings when they're getting ready to go to jail? So everybody kind of has an idea of what's going on behind the scenes right now. And while you're doing that, I'm going to go refill my coffee.
Okay. So I work on the defense team. But I'm in a different county than Sarah is currently. Our people usually change when they get to the court, not at the jail. They're waking up very early and transported to the court. And they change there. We bring the clothes in. Normally, on jury selection, all the jurors who have been called are brought into like a central hall and then sort of dispersed out across the courthouse. And like Judge Kranick just said, he'll bring in 50 people and they're going to start striking them. But what they'll do is they'll turn the tables around that normally are looking at the judge and they'll turn them to face the gallery. And then there will also be, well, at least in my county, we get like a big drawing. Basically, it's a big layout of how many people are going to be in the jury selection. And we get jury questionnaires before anyone's brought up. So we can start filling out these charts. And then when they do the judge will ask questions and then the attorneys ask questions, we can make little notes in the boxes. And it's not so much that we select a jury is that you, how do I say this? It's not like you get to pick. It's like you're fighting to keep jurors in. So a lot of it is one side is trying to get rid of jurors that would be good for the other side, and you end up with some sort of mess in between. So this should be really interesting, in my opinion. Let me see.
I'm still working on my Sarah contradiction video, by the way, everyone.
Oh my gosh.
It's obviously it takes a while because there's so many contradictions.
I have to do that with when I get sworn statements or statements that have been given to the police, and then depositions and sometimes trial testimony. And I have to go through and document all the contradictions. That's exhausting.
Can you imagine living with Sarah Boone?
No.
Talk about exhaustion. Speaking of
it would be
exhaustion.
exhausted. I feel bad for Brian. I mean, he had to have been exhausted. I feel like he was trying to do what he could for Lucas's sake. But
yeah, I think at the end he got some balls, because I did see a clip from where he was speaking in the alimony, or something that she brought up in one of her letters. By the way, she's been writing letters to the judge in
family court
her,
judge?
yeah, the family court as well. And I did see something from SKR, and I'm going to put it up because he shared one of mine, so I figured he was okay if I share one of his videos. But I'm not doing the whole video, and I did do some commentary throughout. So
Alexis W, this is interesting. Carrie, did you know this from
What?
one of our channel members? Alexis W says Kranek is the perfect judge for this case because he was appointed, before he was appointed to criminal, he was DV in domestic relations.
Oh,
Remember I
that's
told you
awesome.
judges cycle out?
Yeah.
So
Yep.
Yep.
You know, speaking of
Take
which,
me
you know, they're
see.
having a big, this month is domestic violence month, and they're having a big thing on over in Orlando. They're trying to, in regard, there like there's a seminar. I think it's tomorrow at 4:00. It was supposed to be. It was like a Zoom seminar on domestic violence. I was gonna watch it and tape it and see what, if you guys wanted to watch it. I was gonna see what it was all about.
There should be no shame when you've been abused by an intimate partner. But sadly, there is. Shame in coming to terms with being in an abusive relationship. Shame in talking about it. Shame in asking for help. The feelings of shame can be overwhelming and also stifling.
So I just wanted to bring that up because I thought that was really sweet or nice what she'd said about that. But we are in domestic violence month, which is why we have purple up on the screen. And that purple is supportive domestic violence. So if you guys put purple hearts in the stream this month, I think that's appropriate for this particular trial.
Justice for Jorge Torrez Jr. should get trending too, says West Coast Mesh Fighter.
Yeah.
I am asking someone who I think is in the courtroom.
No new feeds from there. Update from the docket. Let me look at the docket once more time.
Well, I'm being told by someone in the courtroom that they are not sure whether there's going to be streaming. It is, quote, a zoo in here.
A zoo? Oh, God.
A zoo.
Oh, are they not prepared for this? Do you think
I don't know. I have someone who's there. My question was, are they going to stream from the courtroom today? And the response was, I'm not sure. It's a zoo in here.
I just wonder if, come on. I mean, we're having trouble with audio already. They weren't really too concerned about that. That needed to be taken care of. And now you're going to tell me that they weren't prepared for people coming in to watch this trial there in the gallery. I think that's one of the reasons he didn't want to move it to a bigger courtroom, because he didn't want to deal with all that.
So Deborah Miller is saying that per law and crime, Sarah's clothing from the jail did not arrive in time. So I don't understand that. I told you this the other day. I swear I did. That when we have trials, we bring the clothes to the courthouse and give them to the deputies because they can't change before they're being transported. They have to wear their jail uniforms to the courthouse. They change in the holding room right outside the courtroom.
You think her attorney was late, or do you think one of Owens's people that had her clothes was late?
I don't know. It's so see the bailiffs, or I'm sorry, the sheriff's deputies are who would be in charge of jail things, transport things, and keeping track of Sarah once they're at court. And they may have said, I think in the hearing we heard that the clothes were gonna go to the jail. But I thought that's weird. Okay, so now what I'm taking from this is that it's entirely possible that the clothes went to the jail and they needed to be brought to the courthouse. I asked my person in the courtroom again, is it true that it's been delayed because of Sarah's clothing? And they did not know. 32 years. Oh my God, you guys.
I've got an update. I've got an update from Law and Crime. Boone's attorney said the jail would not let her wear her own shoes, and she currently has jail flip-flops on.
Oh, her slides that she wanted the judge to stand in.
Oh, I love it. I love it. Let's see. The discussion of the forms and the objection, which was overruled, even though the judge previously sustained the state's claim. The objection overruled by state was won by the defense in this matter. After this was presented, her defense was brought. Oh, Sarah Boone was brought. Oh, which I think this is somebody recapping what's already been done. Okay, I've got a picture of her. Oh, okay. Here we go. I do have a picture from the courtroom if anybody would like to see it.
Yeah, put it up. Let's see it. Let's see it.
At least we get something for crying out freaking loud. Oh, that's the dress she chose, a navy blue dress. Can you see it okay? Because I don't know if I can make it.
Yeah, I have my screen like split up into a million different pieces.
If I open it in a new screen, let me see if it looks any better. No.
Angela says it's showing on Court TV.
Okay, hang on. Oh, it is. Okay, I'm there. Thank you, Angela. Thank you, honey.
Court TV says jury selection is up next. What?
Here's another feed from Sarah. The jury should not be able to see. It says, judge says there are privacy panels located in front of counsel's table, and the jury should not be able to see Sarah Boone's feet today. Good Lord. This is so not. Judge will provide an order to the jail after today she can wear her own shoes.
Oh, so she must still be in the jail slides then and not be happy about it. Okay, okay.
So they're still talking about Ackerman over there. So this is the first thing they had of her on Twitter. And then this was the other photo we had on Twitter.
Yeah,
we'll go back to Court TV right now.
First regular close in over 4 years, and it doesn't look any different. That's crazy. Okay, so I see Kathy.
Shackles removed there as we're getting ready for the jury selection.
Oh, there we go.
I don't know if they're going to show a whole lot, but at least we know they got a feed in there. And you know what? I like the angle of the camera, you guys.
Because you can see Sarah?
Yeah. Well, just because it's a better angle when you see the front of everybody.
So it looks like judge is going to do jury selection today and tomorrow. And they won't stream that.
Okay, let me read Kathy's notes here from Law and Crime. She says, Judge would like 4 alternates, but if they can get more, he'd like that. Judge confirms the court is closed Wednesday, and they're waiting to see about Thursday and Friday. Jurors that pass the initials rounds today and tomorrow will be told to call a phone indicating if they are to return Thursday or Friday or next week. Judge says he moved the trial from 2 weeks to 3 weeks because of his concerns to seat a jury due to publicity. This means he does not think they're getting a jury in one day. Plea offer was rejected. We offered 15 years.
Oh, they did?
For
they
lesser
made an offer?
I can't believe that. I just cannot believe that. This is 2 minutes ago.
I'm stunned.
She was offered 15 years for lesser charge of manslaughter. She faces 22.5 years for the top charge of second-degree murder. She rejected the offer.
The 22 years is the bottom of the sentencing guidelines. Yeah, Hurricane Milton's now at Category 4.
Okay, so it says on Twitter that Sarah Boone is in the courtroom, brought in with waist chains, which were removed, clothed in a blue 3/4 sleeve top and black pants. Oh, she's got black pants on. Hair combed back. Surprise, surprise.
I can't believe. Well, I'm not surprised she turned down a plea. I'm surprised the state actually offered her a plea because they seemed really angry. Like when she first was made to represent herself, if you go back and you listen to that first hearing, the state mentions a potential plea twice and then never again. They just got angry with her.
All right, I'm back. Okay, so I'm going to go down this Twitter feed from this Kathy chick and just read it all the way down. And I may end up repeating myself, but I want to make sure we get caught up. Okay. So she says, potential jurors are outside. This was an hour ago. Potential jurors are outside the courtroom waiting for the jury selection to start. We are not allowed to broadcast jury selection. We are not allowed to broadcast jury selection. We're waiting to see how the latest hurricane will impact opening statements as that storm is set to hit that area Wednesday or Thursday. Then in the comments, she writes, the court will be closed Wednesday due to Hurricane Milton, and it's a wait and see for the rest of the week. So at this point, they're still talking about being open on Tuesday.
Which is crazy, Carrie, because my county just upped its mandatory evacuations to 2 zones.
It says delayed to the start of the jury selection. She didn't receive her clothes on time. Judge left the bench and asked to be alerted when she's there and ready. Sarah Boone is in the courtroom, brought in with waist chains, which were removed, clothed in a 3/4 sleeve top and black pants, hair combed back. Who cares? Boone's attorney said the jail would not let her wear her own shoes, and she currently has jail flip-flops on. I'm sure that looks really cute with her little black pants. Judge says that there are privacy panels located in front of the counsel's table, and the jury should not be able to see Sarah's feet today. Good Lord. I mean, this is what he's having to deal with. Judge will provide an order to the jail that after today, she can wear her own shoes. Judge would like 4 alternatives, but if they can get more than that, he'd like to. The judge, especially with this hurricane, seems like with this hurricane, maybe they would want to plan ahead for that. Judge confirms the court is closed Wednesday, and they're waiting to see about Thursday and Friday. Jurors that pass the initial rounds today and tomorrow will be told to call a phone indicating if they are to return Thursday, Friday, or next week. Judge says he removed the trial from 2 weeks to 3 weeks because of his concerns to seat a jury due to the publicity. So from 2 weeks to 3 weeks. Okay. This means that he does not think they're getting a jury in one day. She rejected a plea offer. And I mean, you guys, this is huge. 15 years for lesser charge of manslaughter.
Well, stop there for a second, Carrie. Think about that. If she took a 15-year plea, how long has she been in jail?
4.5 years.
Okay,
four years and 7 months.
So she gets gain time, right? So she would get that knocked off. So now you're down to what? 11? She does 85% of 11 and she's out.
She's an idiot. Okay, hang on. I'll be right back. Let me change over to Court TV while I do that. I'll put the sound up.
Trial beginning against defendant Sarah Boone. Jury selection about to get underway. They're dealing with some preliminary matters first. Let's watch.
What are you taking?
Tonics for stomach acid and Lipitor.
When's the last time you took those medications? Are they affecting your ability to perceive or understand? Okay, thank you. All right, the parties have been provided answers to our jury questionnaires and an outline of a seating chart. Just as a friendly reminder, please do not use last names when addressing any member of our venire. Please use paddle numbers. The crime charged in this matter is second-degree murder. I did ask the state to provide a copy of the score sheet to the defense. Has that been done?
Yes, Your Honor.
Okay, and what is the lowest permissible sentence based on the score sheet?
22.5 years, 246 months.
Okay. Ma'am, and there's no offer to resolve this case. Is that correct?
The offer is still 15 years on a manslaughter.
Okay. Ma'am, do you understand the charge in this case?
Yes.
Do you understand that it's a punishable by life felony? Do you understand what that means?
I will be in prison for the rest of my life.
Okay. Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Do you understand the state's offer to resolve this case? Okay.
Can you guys see the video? Can somebody tell me yes in the chat if you're seeing the video?
Yeah, they
on the
can
screen?
15
Okay.
years to a lesser included charge of manslaughter.
God,
The understanding
stupid.
that she would serve 85% of that sentence.
That was
It's up
stupid.
to the department and her behavior, but that is my understanding of the section.
Ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case? Okay. Ma'am, a witness list was filed by the defense. Have you had the opportunity to under review and go over with your attorney those witness lists? Okay.
Judge, I can only go out there certain times, but we've amended the witness list several times. I don't think she's seen the most amended witness list, which I don't know when it was filed, but I'll make sure today during a break and go down and make some copies of the list and bring it back up to let her review.
Okay. Ma'am, we'll circle back on that issue, but in your conversations with your attorney so far, and the witnesses that they intend to call in the case, should you choose to put one on, are there any witnesses that you wanted to call or want to be as witnesses that your lawyers have not listed?
I'm unaware because I don't know what the list is.
Okay, all right. We will circle back and readdress that.
Judge,
Yes, sir.
this case was 4.5 years, and she did instruct us to make attempts to find neighbors in that apartment complex, which has changed hands and people have left. So we've been trying to find witnesses from 30 plus days ago, but we haven't found as many as she wanted us to. We found some that we feel like will be helpful for the defense, but we potentially could have found more, but we did the very best that we could. I'll give her the list, and then we'll bring that up again, Judge.
Okay, we can address that after she's had the opportunity to review the amended list. Ma'am, are you ready for trial?
I am.
Is there anything else you would like to bring to my attention at this time?
No, please, but if I may have water, please.
That's something I got to address with corrections during a break, ma'am. Thank you. All right, with that, we're going to go ahead and ask the state to bring in our jury. Before we bring them in, I'm going to ask the parties to reverse their positioning to be on the other side of defense counsel's tables, please.
Whoa, this was big. Offer rejected. The plea offer that the state of Florida has offered Sarah Boone 15 years on a manslaughter charge, reducing the charge and guaranteeing a sentence for her, she says no. And the judge even cautioned her that if she is convicted on the murder charge, the mandatory minimum he's looking to sentence her would be upwards of 22 years, 22 and a half, I believe, to be exact. She rejected that and wants to take her chances at trial. We're going to follow the jury selection this morning, and also,
Do you see they were turning the desks around? That's what I told you they were going to do.
Yeah,
So
yeah.
turn it around to face the gallery, and then they're getting their jury questionnaires and they're getting the diagram, like I told you guys. It's just like it's usually pieces of paper taped together with squares on them for however many people are sitting can fill the gallery.
Yeah.
Those will be the jurors, and then you fill in the numbers.
So they're going to be, I guess what Court TV is planning on doing today is just showing us a few clips here and there. You guys, I cannot believe that she rejected that. I mean,
everybody in the chat is like, this is insane that she didn't, right? But also, we're here to see her go to trial. I just didn't think the state was going to offer her a plea again. I figured she'd burned her bridges with them.
I did too. I was surprised that they even offered it. I guess on probably out of consideration for the family.
Maybe, yeah. I don't know.
That could have been what it was, because they know that this is going to turn into even more of a media hyped thing now that it's in trial. I mean, think about it. Before it even went to trial, look at the media.
Yeah.
So I guess maybe they were considering that, and maybe, you never know. Maybe the family asked the prosecution, "Can we just be over and done with this?"
I mean, I think you can tell in the way that the state just sounds exasperated and angry.
Yeah.
Yeah.
Oh, golly, that is awful.
Yeah, and Weed Hopper makes a good point. Like, she could have had time with her son as a young person.
Oh, she doesn't care about her son. It's about her. It's all about her.
Yeah,
it's all about Sarah. So what you were saying, Sam, is okay. So if they give her 15 years, you're saying she'd probably get out in 11 for good behavior. Is that what you're saying?
I think it would be less than that, actually. So whatever she's served already since being arrested, that would come off, likely. I'm guessing. Somebody's going to come for me. I'm guessing. So the time she's already in, that would come off. And then if she did 85% of what was left, so estimate 11-ish, then yeah, Mark, it would have probably been around 8 years.
I mean,
it would be under 10. It would be under 10.
I'm just wondering if she's going to turn around and say, Owens made me not take the. Well, she's going to say, he's telling her, and he has to ask her, have you been forced or whatever?
Maybe that's what they were fighting about.
You know what? I bet it was.
Mm-hmm.
I bet you're right. Because that would have made sense if they offered it and gave her some time to think about it.
Yeah, I think that might have been what they were fighting about. She thinks a jury is going to side with her, that they're going to see her as, I don't know, having not done anything wrong.
She's totally oblivious to how she looks to the outside world. Completely oblivious.
Exactly. Just pleas are not always offered. I've got one right now that I really want them to offer a plea because I need him to move on. It's up to the state whether they offer a plea.
What did you say about parole? Florida does not have parole. Did you answer
we
that
don't.
one?
We don't have parole. We have community control and probation. So sometimes they'll sentence somebody to 5 and 5. So you do 5 in, come out for 5 on community control, which means an ankle monitor, the different conditions for different people, depending on what their crime is and their situation. And if they screw up, then back in they go.
I cannot believe she didn't take that. So, okay, let's just do the math here for a moment, please, if we can, just here for a moment. I'm not a mather. I don't math either. I'm horrible at it. I literally had to go to summer school in 2nd grade because I failed math. Okay, so she's offered 15 years. Is that what it said?
Mm-hmm.
15 years. She's already spent, we'll just round it out. She's already spent 5 of that. Okay. So she would have 10 years left. Even if it was just 10 years left, she would get out.
Yeah.
She would get out in her mid to late 50s. But I guess she looks at it like this. Well, I'm going to die in my late 60s, 70s. So what's 10 versus 20 or 30? What an idiot.
Online.
This is what it looks like in the courtroom right now, you guys. And when Court TV comes back up, we'll do that. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. Now, you guys, it's on the docket with those notes on it. Obviously with no documentation next to it yet, so I can't pull anything else up. Court TV has already said that they were not allowed to stream it, but it looks like what they're doing is they're picking and choosing pieces and doing playback on that.
She's freaking out.
Jury selection has been postponed until next Monday, August the 14th, due to Hurricane Milton. That's coming from Court TV. Judge had a long sidebar. He confirmed the court will be closed Wednesday and Thursday this week, and Friday is unknown. Due to the concerns of jurors doing what they need to do to prepare for the hurricane, he has postponed jury selection until next Monday.
Yeah, I thought so.
We kind of saw that coming, didn't we?
I'm not surprised. Not with how this storm is tracking. So you guys, these storms, they are no joke. You know, over 200 people have died from Helene.
Yeah.
So, you know, through 3 different states, I think.
The hurricane forming named Milton has pushed the Sarah Boone case. The judge just announcing it a few moments ago that jury selection process, which was going to be starting this morning, has been pushed until next week. Let's watch the judge.
Thank you so much for letting me know your positions. As we just discussed, as of 10:46 this morning, the chief judge has decided to close all courthouses due to Hurricane Milton, both Wednesday, October 9th and Thursday, October 10. The court anticipates that operations will return to normal on Friday, October 11th, but that's due to the court's continued close monitoring of the impacts of the storm. Due to the potential storm and the ramifications of it, the court is going to postpone jury selection in this matter till Monday, October 14th at 9 a.m. Mr. Owens, please provide the court the order with regard to the clothing and shoes, and we'll address that as necessary. As also requested, please provide my judicial assistant your cellular telephone numbers before you leave today. With that, the court is in recess, and we will see you all on Monday, October 14th. Thank you. Ms. Boone will be returned to the custody of the Orange County Jail pending jury selection. We're off the record. Thank you.
All right, there it is. Sarah Boone was supposed to sit and watch jury selection take place today. Now, earlier this morning, she had a chance to take a deal. The state announced in open court that they were ready to give her a deal of 15 years if she pled guilty for the lesser charge of manslaughter. Right now, she's facing a second-degree murder conviction, which has a minimum of 22 years. Here is that moment where Sarah says no.
Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Do you understand the state's offer to resolve this case? Okay.
15 years to a lesser included charge of manslaughter, with the understanding that she for 85% of that sentence.
That's up to the department and her behavior, but that is my understanding.
Ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Reject.
Oh, man, she rejected that offer. That's 8. You heard that it was 15, but she would serve 8. And she's already done, I believe, 4 in jail, go ripping through these 9 attorneys. She's 4 years away from getting out if she accepted that deal. And she said no. Oh, Deputy Public Defender in Los Angeles County, Philip Dubay, is here. He's been sitting next to clients for decades, listening to their offers and rejections and this. Where does this stand? I mean, this to me seems like a no-brainer. Take it, take it, take it.
Suitcase Sarah is a classic example of why we have a job. Okay, Ted, listen, she's the type of client where you need to double team her, meaning you bring in at least 2 lawyers from your firm or your office to sit her down and tell her to knock off the cock and bull and take the deal. Because when she gets out, she'll be 56. She'll have a whole life ahead of her. You know, she's already been in for 56 months. I believe she got arrested on this in February of 2020. So she'll still be a relatively young woman. Worse yet, when you do the legal analysis, I think the best she can hope for from the jury is a manslaughter. They define it as follows. All they have to do is prove that she committed an act, not in self-defense, that caused death. That's it. All they have to do is hit the play button and show the jury that video of him struggling for breath in that suitcase. And they've basically proven the, of manslaughter beyond a reasonable doubt. So what does that get? The 15 years that they're offering now. Homegirl needs to take the deal and shut up and go do her time.
That'll happen. The chances of a second, while obviously the state is a little bit worried about their case because it is complex. That video, she's not only listening to him, she's taunting him. And there's only 6 jurors that are going to be deliberating in the state of Florida. It's not a 12-person jury. You could just feel this thing going south very quickly, especially if, like they've articulated, their defense is going to be battered spouse syndrome.
Yeah, the only way out of this is to prove some form of self-defense. Because again, they have to prove she committed an act that caused death that was not excusable, meaning it was not in self-defense. And if they think that a battered woman syndrome expert is going to save the day, it's very risky. I would rather take my 15 with all the credit I've got in and be out at age 56 rather than risk life in prison. But she's willing to roll the dice. It's really unfortunate. And this is, again, a classic example of why a few attorneys need to sit her down and explain the risk. And then you can note your files, say she's been advised, and if she goes down on it, she has nobody to blame but herself.
And now it makes sense that she's gone through all these attorneys. We had sort of speculated that the state maybe was offering and she was rejecting, and this, and I think that the state was very eager to get this out on the record and into the public forum. Well, the Hurricane Milton storming towards, or basically Orlando. And now it'll drop in intensity by the time it gets inlet into Orlando. The court was expecting Wednesday and Thursday to have the courthouse closed. This move, though, to stop the jury selection process on Monday and restart it next Monday, I guess that is to eliminate the possibility that you pick a juror, their house is leveled, and they can't serve.
Of course, yeah. I mean, we're fortunate out here where I live. We don't have to worry about having to batten down the hatches whenever it rains or you get a windstorm, you know. But unfortunately, most of the country is not like that. And to be fair, nobody really knows where the jurors live or the jury pool. It could be possible that even though the courthouse is inland, that they live closer to the ocean and they need to get home and board up their windows, make arrangements for their pets, pack things up, put sandbags out and get ready rather than sit serving their civic duty as a juror, you know. So, and by the way, the players in the justice system likewise need to get home and take care of business. The judge, the court reporter, the clerk, a counsel, you know, they all have obligations at home that they've got to contend with to avoid tragic type destruction from what appears now to be a Category 3 or a Category 5 hurricane. You got to deal with it.
Yeah, absolutely. There was a prudent decision for sure. Let's get a break. And
the state's response to the motion in limine has been posted, and it says the state does not object to the defendant's request regarding pages 69 through 71. The state does object to the defendant's request regarding pages 53, 55, 56, and 92. The statements are designed to elicit responses from the defendant, and they did. They are not statements regarding the law or an ultimate issue of fact for the jury. At issue is whether the death was an accident, as she continuously insisted is the case, even as recently as October 1st of 2024, not whether she caused his death. You get that? You guys are saying, you said it was an accident. You've been saying it was an accident, not that it was anything else. Okay. So it says the defendant can request the court to read Florida Criminal Jury Instructions 2.8 recorded interview. Okay. Effective law enforcement statements on the defendant. Yeah, let me read this to you guys real quick. It says you are about to watch a recorded interview that contains opinions and statements by Detective Copsell and Lowen to Sarah Boone. These opinions and statements are pertinent only to explain the reactions and responses they elicit. You are not to consider these opinions and statements by the police officer as true, but only to establish the context of Sarah Boone's reactions and responses. What you think, Sam?
Not surprised. Are you surprised?
No.
No. Not surprised. So I see you guys, some of you are asking about life in Florida. So again, we have sentencing guidelines here, which is like a score sheet. So different crimes equal different points. Sarah scores to the bottom of the guidelines at 22.5 years. And then life would be without parole because we don't have parole. What we have is probation and community control. But no, we don't have parole.
Okay, then there was something else on the docket that just hit. It says state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. So here it is.
Mm-hmm.
The defendant filed a notice and an amended notice. Have you already read this, Sam?
No.
No, I mean, did you read it to yourself already?
Oh, when did it come in?
It just hit the docket not too long ago.
No, then I haven't.
The defendant has filed a notice and an amended notice of her intent to rely on the battered spouse syndrome evidence in this case. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's perception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show in spite of a reasonable perception of danger from the battered spouse, the battered defendant would remain in the home with her batterer, where she would resort to the exertion to, let me put Sam on. Sam's over there flying a kite. I don't know what she's doing. Put it to show, wait, hang on. I lost my spot. To show in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Then it says the defendant, here's the facts. I love this. The defendant has presented several accounts of what happened on February the 23rd of 2020. She made a 911 call at approximately 1 p.m. on February the 24th of 2020. She spoke to a patrol deputy on body-worn camera shortly thereafter, providing a statement to detectives a few hours later on February the 24th of 2020, and providing a second statement to detectives on February the 25th of 2020. The defendant retained Dr. Julie Harper as one of her battered spouse syndrome experts in 2020. Over the course of the next several years, Dr. Harper interviewed the defendant about the events of February 23rd multiple times. Exhibit A at the hearing on this motion will be Dr. Harper's deposition, which was taken on October the 1st of 2024. The state would direct the court to pages 35, 37 through 39. I'm not going to read all those. But anyway, it says, of Dr. Harper's deposition for the defendant's statements about February the 23rd, 2020. The state retained Dr. Tonya, I think that's the way she pronounces it, Werner, as its battered spouse syndrome expert. Dr. Werner evaluated the defendant on October the 2nd of 2024, and Dr. Werner was deposed on October the 4th. Exhibit B at the hearing on this motion will be that Dr. Werner's disposition. The state would direct the court to pages 75 through 79 of Dr. Werner's deposition for the defendant's statements about February 23rd. The state is not asking the court to make any credibility determinations about the defendant's statements to the doctors. That would be for the jury to do. In the full context of a cross-examination with the defendant's statements to law enforcement. What the state is asserting is that as a matter of law, what the defendant has told the doctors does not entitle her to a defense instruction, nor does it entitle her to introduce evidence of prior instances of violence, reputation evidence of the decedent's violence, or battered spouse syndrome evidence to help the jury understand why what she did was objectively reasonable. The defendant told the doctors that because of past violence between her and the decedent, she had a generalized fear every day that the decedent would cause her seriously bodily harm or kill her. However, on this particular day, the decedent did not take an overt action in the slightest that made her believe that he would cause her seriously bodily harm or death. According to the defendant, when she and the decedent woke up, the decedent wanted to drink alcohol. She did not. So in order to distract the decedent, she suggested that they instead clean the defendant's townhome, which they did. At the conclusion of the cleaning, the decedent still wished to consume alcohol. So the two of them began consuming alcohol. The defendant did not the defendant did not want to consume alcohol, but she did so to placate the decedent. Really? Really, Sarah? The alcohol that they consumed was a Chardonnay bottle of Woodbridge. In order to prevent the decedent from becoming sad or upset, she kept him diverted by smoking cigarettes with him, drinking, enjoying each other's company. I can't believe they put that in there. Okay. Perhaps using the dartboard on her porch and doing arts and crafts and puzzles. Although it apparently would upset the decedent, the defendant suggested that he call his daughter, who did not like talking to him when he was drinking, or that he call his brother to tell his brother that the decedent had dragged the defendant down the stairs the night before. Having done these playful activities for numerous hours, there came a point where the defendant and the decedent were sitting on her couch in the downstairs living room, and the decedent tagged her and said, "You're it," from past games of hide and seek. The defendant understood this to mean that he wanted her to play hide and seek. She begrudgingly engaged in this game, as with everything else, to placate the decedent, because she's all about helping others. Because it's not about how she feels at all. You know, she's such a good person. She ran up to the shower after becoming cold, and you're not supposed to turn the shower on, Sarah. After becoming cold and perhaps some misunderstanding about the rules of hide and seek, she left the shower upstairs and returned downstairs to find the decedent placing himself in a suitcase to hide. At this time of his death, the decedent was At the time of his death, the decedent was only 103 pounds and had a blood alcohol level of 0.138. Okay, for you guys that know what that means, please, please, please let me know in the chat, or Sam might know. It says the defendant saw him doing this and decided to zip the suitcase up shut while the decedent was inside it. They were both laughing, and there was still no animosity between them on this day. The defendant states that she did not zip it completely shut. The decedent was able to poke a hole of a couple of fingers through the gap left by the zipper. And then the decedent said he could not breathe. The decedent obviously got mad about not being able to breathe. The decedent's getting mad made the defendant get mad. This reminded her of the past violence the decedent committed against her, causing her to be unable to breathe at those times. This made her angry. The defendant shook the suitcase. Okay, this is getting into stuff we didn't know about, y'all, or that she didn't claim. The defendant shook the suitcase. She lost control, and the suitcase flipped. She hit the decedent's fingertips with the wooden baseball bat that was in the room. Oh, snap. I got to look at the chat.
Oh, my God. I'm unmuting myself. Are you serious?
I know. Okay. Like, I got to see the chat. I need to know what's going on in the chat. I know y'all are freaking the hell out right now.
Still here, guys. I'm here.
Wait, hang on. Oh, my God. Oh, my God. Okay. 1.38 is high, but imagine how much higher it was. Okay. Okay. So back to the bait. So she hit the decedent's fingertips with the wooden baseball bat that was in the room. You guys, I might have to drink after today.
I didn't even think about her hitting his fingers because I don't know what all his injuries were. Wow. Okay. I'm muting.
No, you're okay. Okay. You were just making all kinds of ruffling noises a while ago when you were moving around. Okay. So it says, now, after having committed the independent forcible felonies of aggravated assault, aggravated battery, and the non-forcible felony of false imprisonment, the defendant believed the decedent would kill her. Despite believing the decedent would kill her, the defendant flipped the suitcase over. It was right side up, and she believed the decedent would be able to let himself out. The defendant's specific intent was for the decedent to feel like what it was like for her to choke and not be able to breathe. She intended for him to feel this for 2 minutes and believed only 2 minutes and believed he would let himself out. And when that happened, if she died, she died. She did not intend to kill him, and she did not believe that leaving the decedent in the predicament she placed him in would kill him. His death was an accident. Okay. Legal analysis.
Oh my God.
This is crazy, right?
Well, first of all, can I just give shout out to the state because I love their writing. I love it with the little bit of snark in there. You know, it's so well done.
All right. Well, I'm going to read their legal analysis, and you tell me when you want me to stop so you can talk about it. Okay.
Okay. Go ahead. Okay.
It says battered spouse syndrome evidence is inadmissible if the defense is an accident rather than self-defense. The defendant's testimony is that she intentionally zipped the suitcase out of levity and while kidding around with the decedent during a friendly game of hide and seek. Then, when the decedent informed her that he could not breathe, she intentionally decided, out of anger, to make him feel like he's trapped in there for a couple of minutes while she beat and shook the suitcase and hit his hand with a baseball bat. This is aggravated assault, aggravated battery, and false imprisonment. She stated that she flipped the suitcase right side up, saw that the decedent could not get 2 fingers through an opening. Saw that the decedent could get 2 fingers through an opening, and she went upstairs to bed believing that he would be able to get out in a couple of minutes. She had no intention to kill him, no intent to leave him trapped inside the suitcase, and she did not even comprehend that he could die from this. The defendant is thus still saying that the decedent's death was an accident and that she is entitled to an instruction on self-defense or to a self-defense case with reputation evidence, specific instances of past violence, or battered spouse syndrome evidence. The defendant's statement that she perpetually lived in a state of fear of the decedent is not sufficient to allow for a self-defense instruction, and all of the ancillary evidence of reputation testimony, specific acts of past violence, or battered spouse syndrome testimony. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. And then it states a bunch of case law, and then it says, comparing the facts of those cases, it is clear that there was not even the slightest overt act by the decedent in this case. Prior to the defendant committing aggravated assault, aggravated battery, and false imprisonment, there was no imminent threat from the decedent. You can't just attack somebody as they walk into their front door and slash their throat with a knife because 2 days prior they sent you a threatening text message. That was from one of the other cases. If this evidence is improperly admitted, it would be a departure from the essential requirements of the law, which would result in irreparable harm that cannot be corrected by a post-judgment appeal. The state acknowledges that the defendant is entitled to change her story yet again. Love that, yet again. So if the court does not exclude this evidence now, the defendant should be barred from mentioning battered spouse syndrome evidence until the defendant testifies to something that is a justifiable use of deadly force. And then they do another case law, and it says not improper to exclude expert testimony until the facts are in evidence. And the offense is accident rather than self-defense. So that's it. So I'll let you take it from here, Sam.
No, I actually want to hear what chat has to say.
Oh, okay. Let's go over to
Because
chat.
they've been hearing from me enough. I have questions. I have a question. Was there damage to his fingers? Hello? Somebody asked that too.
Wait. It was not mentioned on the report that I've got, you guys. It was not. Now that I'm thinking about it.
About the fingers. Did we know about the fingers?
It wasn't. I would have had it on the diagram. Wait a minute.
What about the stairs? Did it go down the stairs? Brett asks, yeah, who would admit this? Why would you? Okay, so she admitted it during an interview at the jail, right, with the
With the
expert.
doctors? Yeah, I guess
Yeah,
so.
yeah. And so what the state is saying is she's not presenting the self-defense part of this battered spouse syndrome defense that she wants to put up. This is not that. And they're wanting the judge to say, you can't use that defense. And based on that motion,
Oh, I do have it. Sorry.
Look at that.
Sorry, didn't mean to be so
You're
loud.
good. She flipped it over, so we knew that because we saw it in the 2 videos. But I want to know if the damn thing went down the stairs. I want to know what went down the stairs.
I know that part still hasn't been said, but look here, you guys. Okay, so I wondered when I saw this, I'm like, his knuckles, you guys remember me asking if we thought he was left-handed or right-handed? Because his left knuckle was damaged. It had bruises on it. And then on his right thumb had bruises on it too, though. But I thought, okay, so if his knuckles have damage on him, is it because he hit something or was he, but apparently that's what it must have been, his left hand that he was poking his fingers out of the suitcase. So apparently she was right in that maybe. And that's where she hit him with the baseball bat. And that would make complete sense.
Yeah, I can't believe we've finally got this kind of detail. Caffeinated Slug says they still think that she tossed him down the stairs in the suitcase. That has always been my theory. Where was the bat? Upstairs or downstairs? That's a good question.
I'm disappointed in the state. Are you disappointed? Thank you for being a member for 1 month. Are you disappointed in the state because they offered her a deal? Is that what you mean? You can just put it in the regular chat. I'll go over here and open it up. Lynette says, I feel so bad. She beat him with a baseball bat while he was in that suitcase. So that's where the suitcase comes in, guys. You still there, Sam?
Yeah, I'm sorry. I'm just looking at some weather things. I'm here.
Okay.
I'm stunned. I'm stunned. Are we stunned that we now have this kind of information? I didn't think we were going to get this kind of information. Anyone?
I didn't either. Not today. I didn't. So this is coming from the depositions this is only coming out because they're trying to get this whole batter. So are they saying, I know I just read it, God forgive me, but just for me and the people that still are lost, does this mean that they're saying they're still at that point where they're like, you pick or choose, was it an accident or was it battered spouse?
They're asking the judge to say, Judge, she doesn't qualify for a self-defense battered spouse defense. I mean, it's in there. They found out all the facts, right? They said she committed aggravated battery, it's not kidnapping, but false imprisonment, all these different crimes. This is insane. Like, I can't believe she told them everything. Mandy, thank you for your super chat. How will jury believe this when she was obviously blackout drunk? It's fabricated. It's emoji.
Carolina says that he wasn't thrown down the stairs and his injuries are consistent with him being beaten inside the suitcase. She was mad because he didn't go upstairs to find her. You know what?
That's what okay, go ahead.
No, I was going to say that's it. That's what it is. It's all of our, none of us said that. Did any of us say that when we did our little salacious speculations?
What did we say? What?
Maybe some people in the chat did. Did anybody ever say that she beat the suitcase with the baseball bat?
So yeah, some people. I think some people in that stream did. Yeah, I don't remember who it was.
We'll get back together again. If we're not gonna stream her this week, we'll definitely have another live. Because God, it's only Monday, y'all. We got a lot of time to fill. So we'll get back together again. Stay tuned. Y'all be safe out there. If you're in Florida or anywhere near the storm path, please do what you got to do. Take care of yourself and your pets. Take care of your pets as well. Love you guys.
Bye.
Bye.